So welcome back everyone to the second video in this series on non-fatal offences. Today we are going to have a look at the offence of assault occasioning actual bodily harm, which you can find at section 47 of the Offence Against the Person Act 1861. More specifically, Joseph Chamberlain students, you can find it on pages 13 and 14 of your booklet that looks a bit like this one. But before we get started on that, let's have a look backwards at some things that you learned in the previous video about assault and battery. I'd like you to have a look at this very short scenario question, and I'd like you to identify the offence, state, explain, apply the actus reus and the mens rea, and use cases in order to do so. So you've got the structure that you're going to use at the bottom: state the actus reus, explain it with the case, apply, state the mens rea, explain it with the case, apply, thinking about is it direct intent, oblique intent, recklessness, or in fact no mens rea at all. And your scenario is quite simply this: Jamil texts Cal, "I'm gonna get you." So you're going to have to think about, well, does it fall within the actus reus of the offence? Does it fall within the mens rea of the offence? So I'll give you some time to do that. Right, let's move back to section 47, assault occasioning actual bodily harm. From now on, I'm going to refer to it either as section 47 or ABH, because it is a bit of a mouthful. But the first time you talk about it in an exam situation, you must, I'm afraid, include all of the detail on this slide. So you have to call it section 47 of the Offence Against the Person Act 1861, meaning assault occasioning actual bodily harm. That took me nearly 30 seconds to say, so it's going to take you a little while to write it down. So you need to learn it and learn it accurately, please. So let's split it up into its component parts. So the actus reus is an assault and or a battery and occasioning actual bodily harm. If you only have an assault or battery, you've only got assault or battery. It's got to occasion that actual bodily harm. And the mens rea is intention or recklessness to cause the assault or battery. So essentially what you've got is a defendant who causes an assault, victim fears immediate unlawful force, or a battery where they apply that unlawful force, sometimes both, but they happen to cause a further injury. But note the mens rea. No mens rea is required in respect of that injury, only the assault or battery. That is a key point that you need to really get sorted. Before we go any further, I'd like you to take a few moments, please, to have a read over pages 13 and 14 in your Joseph Chamberlain booklet, just to make sure that you really know what we're looking at. So the mens rea, as I say, intentional recklessness to cause assault or battery. No foresight of injury is required, so you don't need to know or think or want or even have considered that an injury may take place. So the punishment, it's a statutory offence, section 47, statutory, carrying a maximum of 5 years imprisonment. So let's have a look in a little bit more detail about what that actual bodily harm bit is and the difference between an assault and a battery. Well, actual bodily harm requires one or more of these things. And hopefully you will see that they're nasty, don't get me wrong, they are unpleasant things to happen to anybody, but they are not really, really serious life-changing injuries. They're the sort of injuries that would keep you off college for a couple of days. You probably would go to A&E. You wouldn't be off college for a very long time, nor would you go to hospital in an ambulance. You'd probably take yourself there. So it's things like losing or breaking a tooth, loss of sensory function, so unconsciousness, extensive or multiple bruising, so not just one bruise, that wouldn't be sufficient, but some quite nasty bruises, a displaced broken nose, minor fractures, a minor but not merely superficial cuts, and it's going to be the sort that's going to require medical treatment, not just plaster, And it can be psychiatric injury, which is more than fear, distress, or panic. So what you're going to do in a moment is have a look at these cases that you can see on the screen now. So we're going to look at Miller, Chan-Fook, T and the DPP, Smith, the hair one, you'll find out why in a moment, Savage and Roberts, Savage and Roberts being your mens rea cases. The leading case that you need for the actus reus of ABH is R and Miller. Now the facts, a horrible case, husband was abusing his wife. He would push her over, and every time she got back up he would push her over again until she went absolutely hysterical. It had a really nasty lasting impact on her. But in obiter dicta, the judge said this is your definition of actual bodily harm, because it's not a phrase that jurors are going to easily understand. It's not going to be one of these phrases that's immediately obvious just from the wording. And the judge said actual bodily harm means any hurt or injury calculated to interfere with the health or comfort of the victim. And that can include mental and physical harm. So something that interferes with your health or your comfort is going to have, like we said, an impact. It's going to be with you for a few days, but it's not going to have a lifelong impact. So Chan-Fook is also an actus reus case. So in this case, you have a shopkeeper who suspected the actual victim in the end of shoplifting, so he locked them in a room, and they became very, very upset, and they also went hysterical as a result. And the question was around, well, can actual bodily harm be psychiatric or psychological harm? And in Chan-Fook we're told, yeah, absolutely. Harm means injury, physical or psychological, but it doesn't mean just mere emotions, not just fear, distress, panic. And the word actual means not so trivial as to be insignificant. T in the DPP illustrates that a loss of consciousness can be actual bodily harm, which is exactly what happened in this case. Our victim is kicked repeatedly and the victim loses consciousness for a moment, and that was sufficient for ABH. And in DPP and Smith, this illustrates the interfering with somebody's comfort. Smith went to the home of his former girlfriend, and during an altercation he grabs a pair of scissors and he cuts off her ponytail, all of her hair. And it was held by the court that cutting off the ponytail was ABH. A hair is an integral part of the body and it's intrinsic to each individual. If somebody came along and chopped off all your hair, you'd be very upset about it for more than a few days. So clearly when you feel it like that, it's sufficient for ABH. Savage is one of your mens rea cases, so you can write this on page 14 in the right hand column in the bottom box. So in Savage, the facts, you'll have to visualize them. I'll give you something to help you with that in a moment. But the facts before we start. So our defendant intended to pour beer over her ex-husband's new girlfriend when they met at the pub, and that was going to be sufficient for battery. But unexpectedly and unbeknownst to Savage until it happened, the glass slips out of her hand as she goes to do this, and it does more damage. It causes cuts to the victim. Now, where the crime states that the mens rea is maliciously, we know that this requires either intention or recklessly. But we're told from this case that no foresight of the injury is required. So we're talking about intention or recklessness to cause assault or battery. No further mens rea is required in respect of the actual injury itself. So in Savage, our defendant is liable for actual bodily harm, carrying a maximum 5-year prison sentence, even though all she wanted was a battery to pour beer over the woman. Because she had the actus reus of battery, she causes the actual bodily harm with the cuts, and she has the mens rea of battery. It's her aim or purpose, her direct intent. So we see similar facts in the case of R and Roberts. This is Roberts, who was taking his victim home in the car, your causation case. So the defendant in Roberts was guilty of section 47 even though he hadn't intended any injury or even realise that there was a risk. If you remember in Roberts, he had told his victim that he would drive her home from a party, and on their way the victim realises that he's not going in the right direction. When she says something about it, he then starts to try and take her coat off and makes it quite clear that he's going to sexually assault her. So she waits for the car to slow down and jumps out. And it was held that he intended to apply the unlawful force when he touched her and tried to take her coat off, and therefore his mens rea in that respect was sufficient to make him liable for the section 47 as well, even though he had no foresight of the injury. So in both Savage and Roberts, you have defendants who intended a much lesser offence. In their cases, we're going to focus on the battery. We're going to ignore the sexual assault part for Roberts because that isn't actually relevant to what we're going to look at. So they both intended a battery, and battery, as we know, the maximum sentence is 6 months. But because they ended up causing a much more serious offence, they are convicted of actual bodily harm, which carries a maximum 5-year prison sentence. But they didn't foresee that as a possibility. So I'm just sort of planting a seed in your mind at the moment to think about, is it really fair to convict these people of an offence that they didn't foresee? On the other hand, you have to think, well, they did cause the offence, and they were intending an offence and they ended up causing a more serious one. So would it be right not to hold them responsible? Some things to think about for later. So what I'd like you to do just for a moment, just to really hammer home what we've done, you've actually got some space at the back of your Joseph Chamberlain booklet if you'd like to do this. Without your notes, I want you to write down the actus reus and mens rea of assault, battery, actual bodily harm. As a stretch activity, I'd like you to add in the maximum sentence. We've spoken about them in this video, so there should be no excuse on that one. And a case for the actus reus and mens rea of each one. Once you've done that, feel free to upload a photo onto Google Classroom and I'll have a look if you'd like me to. And you can check your notes by going back through your booklet. And so now you're in a position that you can start having a look at some scenario questions. So Joseph Chamberlain students, we are now on page 17, really getting through this booklet. This is your last booklet of this academic year, can you believe it? So your scenario is, after a fight with a drunk in George Square, Paul is taken to hospital. He's suffered heavy blows to his face that resulted in extensive bruising and the loss of 2 teeth. The drunk had intended to hit Paul but not cause him such harm. So you need to think whether the drunk person in George Square is liable for section 47 actual bodily harm. So we'll have a look at it in exactly the same way as we looked at the previous offences of assault and battery. So this is how you're going to go about applying to your scenario with Paul. So first of all, you're going to say that due to the level of injury, it appears that the man may be liable for section 47 assault occasioning actual bodily harm from the Offences Against the Person Act 1861. So you always start with your assault or battery. It's the most important thing to start with, and you always start with the actus reus of whichever one that is. And you have to ring fence yourself here to the assault or battery. I don't want to hear anything about injuries until we are onto the second section. I'll tell you where the injury comes in. So you state the actus reus of the assault or battery. Well, here he's been hit in the face. That's a battery. So you say it's the application of unlawful force. You explain it with the case, Turner, unwanted touching works perfectly well. You then apply. In this case, the drunk man applied unlawful force to Paul's face. This is a battery. I only want to hear about the application of the unlawful force. You then go on and state the mens rea of your assault or battery. Intentional recklessness to apply unlawful force. You explain it with the case of Venner. Recklessness is sufficient for assault or battery. And then you apply the level of mens rea of the assault or battery. So it would appear that the drunk man had direct intent to apply unlawful force to Paul's face, as by carrying out the action of throwing a punch into his face, he achieves his aim. He got what he wanted. He wanted to touch his face with his fist. Now, and only now that we have established all the way through your actus reus and mens rea of either your assault or battery, then you move on to actual bodily harm. So you state the actus reus, assault and or battery occasioning actual bodily harm. You explain it with the case of Miller, any hurt or injury calculated to interfere with the health or comfort of your victim. And you apply, in this case, the ABH is extensive bruising and the loss of 2 teeth. This would interfere with the health or comfort of the victim. So I've just used exactly what the scenario said and said this would appear to interfere with your health or your comfort, as in Miller. So I've used the law, the scenario, to really tie it together. I then state the mens rea of ABH, intentional recklessness to cause or assault or battery. I explain with the case of Savage, no mens rea is needed in respect of the injury, just the assault or battery. And then I apply by saying, I have already proven the mens rea of your assault or battery over here, so I don't need to prove any further mens rea, and therefore your defendant is liable for actual bodily harm. So just a little point about guilty/liable. The role that you are taking when you're doing these scenario questions is as the lawyer. You're not the jury, you're not the magistrate. So you can't say that our defendant is guilty, because that's not your job. You are advising your client, the drunk man, wonderfully named in this scenario, as to whether or not he is likely to be held liable and is likely to go to court. So to finish off, please, I'd like you to use this structure. So it's the structure that you looked at before. And I would like you to use it on the following scenario on page 17. So George was running to catch a bus at the stop ahead of him. He barges past a group of people. Unfortunately, one of the group falls over and suffers a sprained ankle.